Okay. So we're going to discuss Cristen Martinez. She's a lawyer, does a lot of real estate stuff there. I love following some of her contacts, actually most of her content, dealing with a lot of legal issues and so forth like that. We are every day changing to more and more paperwork and more of the legality, more specific in the way we talk to our customers and other agents, and the way we do. How can I say this? The way we're discussing contracts and through emails and through text versus talking it over the phone. So we're going into a new world. Okay. So I listen to what she has to say, and then I'm going to talk about it a little bit more after the fact.
Florida realtors, don't make this mistake. I'm a real estate attorney here in the state of Florida. I'm working on a very messy case, and the whole thing could have been prevented if the realtors involved would have followed this one rule. And that is, do not negotiate purchase and sale agreements through email. I'm going to repeat myself. Do not negotiate purchase and sale agreements through email. Why? Let me break this down for you. So real estate contracts are subject to the statute of frauds here in the state of Florida. What does that mean? That means they have to be in writing and they have to be signed by the party against whom it is going to be enforced. So if the buyer wants to sue the seller, the buyer wants to enforce the contract against the seller, the only party that has to sign the agreement is the seller for the statute of frauds to be satisfied. So when we're talking about negotiating terms by email, two key things come into play. Number one, we are talking about real estate agents acting on behalf of their buyers and sellers. As an agent of your buyer or seller, you as the real estate agent can bind your buyer or seller because your actions in the course of your listing agreement or buyer broker agreement is the same thing in the eyes of the law as your client actually taking those actions him or herself. So the first thing is the principle of agency. Anything that you do within the scope of your working relationship with your buyer or seller will bind your buyer or seller. It's the same as if they took those actions directly. The second thing is the statute of frauds. So if you are sending an email saying negotiating contract terms. So we'll take this purchase price, this inspection period, this contingency, this closing date. Is that okay with you or with your client? The other realtor responds, yes, that's okay with my client. We agree. But then no purchase contract is signed. We have a writing. So the email exchange constitutes a writing for the purposes of a legally binding agreement and satisfaction of the statute of frauds. And if you use, as a realtor, electronic signatures on your email, there are courts in the state of Florida that have interpreted that as a signature under the statute of frauds, meaning that is a signed writing. So even if in that example, offer is made by email, it is accepted by the other agent by email, but when the contract is drawn up, the parties are like, no, this isn't what I wanted. I'm not signing this, and there's no purchase contract. That email exchange, assuming all material terms are included in it, can be enforced as a binding agreement, and now you have some really mad buyers and sellers. So what do you do instead? You only negotiate terms of the purchase and sale agreement on the purchase and sale agreement itself. All offers should be made by providing a contract signed by the buyer or the person making the offer to the other party. Any counter offers are to be made on either a new contract or striking through or attaching addenda or on the contract itself. Never, ever, ever negotiate terms by email, by text message, any of that.
Okay, great. So now we have to start be very careful on what we're sending in emails, because it could become hairy as all the scenarios that she applied. What do we do? How do we protect ourselves? If you have an email, and I just show you real quick, my signature real quick. As you hear, I put here right there, I just wrote it down, the disclosure, the information provided in the email, price, terms, conditions, discussion purposes only, and says does not constitute an offer, an agreement, or legally binding commitment. Any such terms and subjects are not enforceable until formally agreed upon in writing and signed by both buyer and seller. These terms may be revised or modified at any time prior to finalizations and execution of the binding written contract. Add that to your emails. I will dare you to do the same thing for your text. Just because, especially if your text has a signature, because a lot of people are putting signatures on there, so we have to be careful what we're texting. Now, with that being said, if you're sending out emails now, okay, put this in there. Dot loop. You know how we send the contracts to the buyer or to the seller. I would also put in their disclosures. You know how you type in the comments. I usually put in if you're sending it for a new offer or a revised offer or a counter, I would definitely put in there to your client to please review the contracts, okay, and to sign if agreeable. Okay. I wouldn't go into details on all the, what the contract says, because that could be, I want to say that it could be interpreted as that you are reviewing the contract like a lawyer, and you don't want to do that. So I would say send this over to them. Just put please review and agree. Or if you want to put a couple key points, say, hey, there's a couple key items that you should be aware of. The price, the terms, the time. Please review the rest of the contract as well for all the other issues. Or if it's a counter, hey, this is the same contract as before, and the only changes are line 102, 104, 355, whatever. I'm just throwing some make-believe numbers or line items, if you will. This way they can just know those are the only changes. Make sure you review that contract and make sure that's the only changes. Have them initial each of those changes, so this way everybody's good to go. Okay, guys. If you have more questions that specifically, give me a call. I'd be more appreciative, more than happy to sit down with you. All right. Have a great day. I'll talk to you soon.